always providing for us in our times of need. We pray that you will bless this activity this morning. We pray, O Lord, that we will keep you at the center of our lives and the affairs of our country. Lord, we give you praise and all the honor. In Jesus' name we pray. Amen.
Good morning, everybody. Please have a seat. The Honorable Minister for National Security and Home Affairs will be with us shortly. I want to recognize the Minister, the Acting Director of Public Prosecution, Mr. Marital, the National Disaster Coordinator, Mr. Pascal, the members of the press, thank you very much for being with us on short notice. And to the listening and the viewing public here and abroad, I want to wish everyone a good morning. The topic for discussion today is the Sexual Offences Act, Chapter 1036 of the 2017 Revised Laws of the Commonwealth of Dominica. This is in keeping with the declaration made by the Ministry through the Honorable Minister for National Security to continue to interface with the public on matters of national significance and importance. Due to recent occurrences, and we all live in Dominica, we know what's going on. It is time, I think, to shine a light on the legislation surrounding this very important issue that affects many Dominicans. The Sexual Offences Act of the Commonwealth of Dominica is a robust piece of legislation. And today, we want to give the public a look at some of the more salient elements of the Act, as well as the penalties. So we're very honored here today to have the Acting Director of Public Prosecutions with us, Ms. Dalrymple, who is an excellent technician, a wonderful attorney, and a colleague, and I have the pleasure of calling her my friend as well. So Ms. Dalrymple, I will call on you now. The Honorable Minister was scheduled to give some remarks, but he can always give them at the end. We're also going to have a little segment where the press can interact with us if you want to ask any questions, and that will be after the presentation. So without further ado, I will ask Ms. Dalrymple to go ahead and begin her presentation.
Good morning, all. With the apparent increase in sexual matters being prosecuted before the courts and the sentencing of sexual offenders as of recent being criticized and questioned in the public domain, the Ministry of National Security and the Office of the Director of Public Prosecutions has deemed it necessary to discuss the area of law and to clear up certain misunderstandings and misconceptions which may exist in respect of the laws of the Commonwealth of Dominica governing sexual offenses. Firstly, we must start at what governs sexual offenses in the Commonwealth of Dominica. And the robust legislation which my colleague, the PS, has referred to is the Sexual Offences Act, Chapter 1036 of the 2017 Consolidated Laws of the Commonwealth of Dominica. My office, having done a comparative analysis of the Sexual Offences Act of both the CARICOM and OECS jurisdictions, can firmly say that our act in Dominica is the most stringent and comprehensive Sexual Offences Act. It must be brought to the attention of the public that in 2016, the legislature deemed it necessary to make certain amendments to our Sexual Offences Act. What is also very important to note about these amendments is that numerous offenses were also added in the Sexual Offences Act, and the penalties were significantly increased. The Sexual Offences Act is not discriminatory nor gender biased. Therefore, the Sexual Offences Act is aimed at challenging society's current attitudes towards sexual offenses and to transform the approach individuals place on sexual offenses while catering for practicable gender equality and protection for both minors and adults. Some of the penalties which are found pursuant to the Sexual Offences Act as follows: rape, unlawful sexual connection, incest, unlawful sexual intercourse, gross indecency, indecent assault, burglary, grooming, prostitution, voyeurism, abduction, unlawful detention of a person with intent to have sexual intercourse, bestiality, procuring a minor to have sexual intercourse, to name a few. I have listed 14 thus far, and there are many more offenses under the legislation. Pursuant to the Act, all these sexual offenses have prescribed maximum sentences for offenses. For example, rape carries the penalty of 25 years imprisonment, while rape of a child under the age of 12 or an elderly person carries the penalty of life imprisonment. Noteworthy is that whether complainant is under the age of 12 or is an elderly person, or where the offense is committed by 2 or more persons or committed in a heinous way, or where the complainant was pregnant or became pregnant because of the offense, or the offender has been previously convicted of rape, that person may be liable on conviction to imprisonment for the remainder of their natural life. This section is important as it shows the upward movement of the punishment based on the severity and holistic circumstances surrounding the act of rape. There is also the offense of unlawful sexual connection, which is the introduction to any extent into the vagina or the anus of any person of any part of the body of any person or any object held or manipulated by any other person otherwise than for bona fide medical purposes, or connection between the mouth or tongue of any person and any part of the genitalia or anus of any other person. Unlawful sexual connection carries a maximum of sentence of 14 years. The sentence for unlawful sexual connection carries the maximum also of 25 years where an object is held or manipulated by another person in the vagina or anus of another individual. There is also the offense of unlawful sexual intercourse, which carries a maximum sentence of 14 years where the minor is 14 years of age or under, but under the age, where the minor is 14 years of age and older. But where the minor is under the age of 14 years, the sentence is 25 years imprisonment. I'll repeat in respect of that. Where the minor is 14 years of age, the maximum sentence that can be given is 14 years and under is 25 years, and where the minor is 14 years is under the age of 16 years, the maximum which can be given is 14 years imprisonment. It must be highlighted that the Act is so stringent that according to Section 36A, I believe that this is the most important amendment that was made to the legislation, that is Section 36A, that where someone is convicted of a sexual offense, the court can give a maximum sentence of 2/3 of the sentence stated in the legislation. For example, I'll put it simple. If the maximum sentence is stated as 15 years, the court is mandated to give a sentence of 10 years and not go any lower. So the court is mandated to give a sentence of 2/3 of the maximum sentence. And Section 36A is a section of the law that strays away from sentencing guidelines. Lately, there has been a lot of talk about guidelines and what are sentencing guidelines. Let me briefly tell you about sentencing guidelines. In 2019, The Eastern Caribbean Supreme Court passed guidelines to deal with sentencing in various offenses. The purpose of these guidelines was to allow for consistency and consideration of the proper facts and circumstances. According to the guidelines, all sentences must be clearly expressed and the reasoning given. Factors taken into consideration, whether as aggravating or mitigating factors, should be set out as part of the sentencing remarks. Any departure from the guidelines must be explained as part of the reasoning. The guidelines for sexual offenses are being used by the court in sentencing for sexual matters. And these guidelines are available online. If you log on to the ECC Courts website, this is eccourts.org, that's the Eastern Caribbean Supreme Court website. All sentencing guidelines are stated on the website. It must also be noted that these guidelines are very mathematical and differs to the pre-2019 method of sentencing, where allowance was made for attorneys and the court to make reference to case law and to other sentences passed in other jurisdictions. The sentencing guidelines we have now for sexual offenses, they do not make room for that. What we can do is we can refer to the statute. Now, in 2016, our law was amended to include section 36A, which speaks to a departure from guidelines. That is, it gives the court the ability to give a mandatory minimum sentence, which is 2/3 of the maximum sentence as stated. And it gives you circumstances when this can be employed by the court. The aggravating factors listed under section 36A of the Sexual Offences Act as follows. The accused committed the offense in the company of another person or persons. At the time of or immediately before or after the commission of the offense, the accused used or threatened to use a weapon. At the time of or immediately before or after the commission of the offense, the accused caused bodily harm to the complainant beyond that inherent in the commission of the offense. D, the accused confined or restrained the complainant before or after the commission of the offense. The accused, in committing the offense, abused a position of trust, authority, or dependency. The accused is a member of the same family as the complainant. The complainant is a minor under the age of 16 years or an elderly person. The complainant contracted HIV or any other sexually transmitted disease or was made pregnant as a result of the offense, and the complainant has a physical disability or mental disorder. So what the law is saying, according to section 36A, that where any of these factors exist, the court can give a mandatory minimum sentence, which is 2/3 of the maximum penalty stated by the law. So, put simply, the court cannot go lower than 2/3 of the maximum sentence as stated by the law. So this is how stringent our Sexual Offences Act is and how serious the legislators have looked at sexual offenses in Dominica. The fight against sexual abuse against minors cannot only be fought against by the prosecution, the police, and the courts. The approach which has to be taken is that medical practitioners, welfare officers, teachers, parents, and guardians have to be on board in that fight. The public must also be cognizant of the fact that the Act has placed duties on parents, guardians, teachers, medical practitioners, registered nurses, and midwives. Section 31A of the Act places a mandatory reporting requirement. I will repeat that, Section 31A. This is an amendment that was put in 2016. Places a mandatory reporting requirement on the following individuals: parents or guardians of minors, an individual who has actual custody, charge, or control of a minor, an individual who has temporary custody, care, charge, or control of a minor for special purposes, as his attendant, employer, or teacher, or in any other capacity, a medical practitioner, or a registered nurse or a midwife who has performed a medical examination in respect of a minor. This section 31A, which creates the mandatory reporting requirement, is far-reaching. Basically, anyone who has guardianship, care, and control over a minor has a duty placed on them to report incidents of sexual abuse against a minor. Now, this section has also been criminalized. A breach of this section can result in a fine of $30,000 or an imprisonment for a term of up to 5 years. So this section is criminalized. The prosecution can bring an individual who does not report an incident of sexual abuse against a minor to the court, where they can be fined up to $30,000 and can be imprisoned up to 5 years. Further, the seriousness of the Sexual Offences Act is also made apparent by Section 31B, which creates an offense where, in circumstances, an individual willfully prevents or obstructs the prosecution of a matter under the Act. In respect of obstruction prosecution, a person who is found guilty will be fined up to $50,000 and can be sentenced for up to 5 years imprisonment. So where an individual decides to pervert the course of justice to prevent the case from going through in the courts, the Act also mandates that this is a criminal offense and someone can be charged up to $50,000 and be sentenced up to 5 years imprisonment. It must also be noted that in the Commonwealth of Dominica, there is also the Criminal Law and Procedure Act, which speaks to perverting the course of justice. And this is an indictable offense, and the prosecution also has the ability to charge under this act as well, where the prosecution of a sexual matter is being obstructed. Members of the public, it has to be impressed on you that the law exists to rid our society of these sexual offenses. Your help is, however, needed in implementing this comprehensive act that we have in Dominica. For us to be successful in this fight, everyone has to be involved. The prosecution and the police are bringing the cases before the court so that justice can be obtained. But the work can't be done unless members of our society take on their responsibilities and report the incidents of abuse and ensure that they work with the prosecution and the police in securing convictions. At this juncture, it is significant to note that over the past 2 years, the Office of the Director of Public Prosecutions has had a 100% conviction rate for sexual matters that have been tried in the High Court. I, along with my state attorneys, work tirelessly in ensuring that convictions are obtained in the High Court. Also, when matters are brought before the Court of Appeal, we also go over and beyond in defending these appeals. As of recent, we were successful in a sexual appeal before the Court of Appeal. That is the matter of the state and Alson Woodman. A lot of victims have also complained of delays in the prosecution of matters, and we have decided, with consultation with the PS, that the best way to deal with that is through the reintroduction of paper committals. And we started doing paper committals in 2020. This is a process whereby the minors are not made to give evidence in the magistrate's court. What happens is that we present their statements in court and the matters are sent to the High Court. So this is a tool that we have been using to prevent matters from being drawn out through preliminary inquiries. The downside to this is that frequently parents of minors come to my office to indicate that they're no longer interested in matters. This is a downside. We have to ensure that the wheels of justice are allowed to turn. Over the past 2 years, from February 2020 to present, only one individual came to see me in respect of noting what was the status of their child's matter. But in that time frame, 11 individuals have visited me to have meetings with me in respect of discontinuing matters concerning their children. This is alarming. We have to ensure that we allow the matters to be brought to court so that the children can get justice. I will again add yes, life sentences can be imposed for rape, as I spoke of earlier, under the 2016 amendments that we have provision is made for a life sentence for rape. This is very important, where the child is of a certain age, where it's an elderly person who was raped, we can impose a life sentence for rape, and this act makes provision for the mandated minimum sentence. In closing, it has to be emphasized that the tool exists to rid our society of the sexual offenses that are now on the upsurge. That is the Sexual Offences Act. This act has been around since 2016. It is comprehensive and it is very stringent in respect of the penalties that are imposed for various offenses. I listed 14 offenses today. There are many more offenses under the Act. What we need to do as a society to fight this, to fight the prevalence of these offenses, is to ensure that we carry out our obligations and our responsibilities which the Act has placed on us. Do not shy away from reporting. Do not advise parents of guardians that, you know what, go and see the DPP and take out that matter from the system. I don't like the child coming to court. No. There are ways and means that these matters can be fought and our minors can get justice. Yes, we spoke also of grooming. Grooming is an offense under the Sexual Offences Act, and it carries the weight of 14 years imprisonment. With grooming also comes certain other grooming type offenses, which is procuring a minor to have sexual intercourse, procuring a minor to be engaged in prostitution. So we have all sorts of offenses under the Act. And again, our Act is the most comprehensive. I boast our Sexual Offences Act in the region. So it's time that we start using it.
Madam Deputy, I think that was a brilliant presentation. I really want to thank you for that. I think the topic of grooming, particularly, I was waiting to speak of that because I don't think that we have enough of a cognizance of what grooming is and the forms that it can take. And I know that one of the popular elements of grooming is that people don't only groom the children, but sometimes they groom everyone around the children to kind of turn a blind eye to the abuse. So I think it's very important that we have these discussions and get out of our comfort zone and talk about these types of things. Honorable Minister, you were called to do opening remarks, but I will hand over to you now so you can give your remarks.
Thank you very much. Let me thank Ms. Shema Darampo, who is the Director of Public Prosecution, for excellent presentation. Ms. Dalrymple is an excellent technician in what she does. I also want to commend the Permanent Secretary. What we have said in the past, that the Ministry of National Security and Home Affairs will time and time again interface with the public to educate and to edify the public on various aspects of our laws. We believe, therefore, that a citizen who is informed and who is versed on relevant statutes as it refers to his country is indeed a better citizen. What we have seen in the recent past, as we heard from the Director of Public Prosecution and the Permanent Secretary, is expressions of concern insofar as the increase we have seen in the prosecution of sexual offenses, especially relating to minors. And what we have tried to do is some of the comments that we have heard and the expressions we have heard in the past, we think are sometimes predicated on misinformation and misunderstanding of the relevant statute, that is to say, chapter 1046 of the laws of Dominica. And that is why we decided this morning to engage the public and to provide relevant information out there. So because it's going to actually entail a collective endeavor whereby all of us within society have to play our part in giving protection to the most vulnerable in our mix, namely our children and people of advanced age. The Sexual Offences Act is a gender-neutral piece of legislation in that it provides protections for both females and male. There's a number of instances you have little boys who are being violated and elderly people of both sexes. One of the things that we did in 2016 when we were actually meeting with various stakeholders to inform us to how do we proceed with the development of a comprehensive piece of legislation insofar as sexual offenses are concerned in Dominica, we look at, as we heard from the Director of Public Prosecution, a number of, from a comparative basis, a number of pieces of legislation that obtained in our sister islands. And we engage, of course, one of the best technicians in drafting, Mr. Harris. And we ensured that that piece of legislation was perfected, and it spoke at the time and still speaks to our current realities insofar as the offenses are concerned. And what we were able to do, because our Sexual Offences Act is still seen as one of the most progressive, we got an invitation by the Commonwealth Secretariat. And of course, where the then Speaker of the House, Alex Borden-Knight, and myself went to England, and there was a global conference, so to speak, on Dominican law insofar as sexual offenses was regarded as the most progressive. I can recall that when we were actually taking that piece of legislation in the bill form before Parliament, I was amazed by the number of messages I got on my phone by a number of people who felt that the proposed piece of legislation was too far-reaching, especially with a very famous, I think, this amendment, which speaks to that a male or female who is in a marriage relationship can rape each other. And some people misunderstand and misconstrue certain elements of the Bible. I wanted to use the Bible to justify the fact that if you're married to a woman, she cannot say no to have sex. Absolutely ridiculous. I mean, a woman saying yes or I do does not mean or should not be interpreted I do to rape. It's absolutely pathetic. And likewise, the same obtained to men. But a number of men are actually not happy with that piece of legislation because they know that we still live in a male-ordered society and the victims are more or less women. So we'll continue in the future to engage the public and to engage the media in other aspects of our laws that we, of course, that we need to be edified on, and so we can know our collective responsibility. The issue about, protecting the vulnerable in our mix, protecting our minors, those people who cannot fend for themselves, the responsibility is resident in each one of us. The prosecution by itself cannot successfully bring matters before the court if, firstly, they're not reported. So fundamentally, the obligation is on you and also on me. If you're a teacher, if you're a nurse, if you're a doctor, if you're a pastor, and you have in your care any minor, and you know of any violation against that minor, you're obligated by law to report that. What happens normally is that when people point fingers in the wrong direction, so when things go bad, the person to blame the most is a politician. We have done, of course, we're not perfect, when we have to be given blows when we deserve blows. But when we go to Parliament and we pass pieces of legislation with specific intention, the intention has to be felt when that piece of legislation or elements of that piece of legislation are actually applied within various court settings. That is when the pith and substance of any piece of legislation is tested by way of intention, is by the actual application of that piece of legislation. So I think it's a wonderful experience for us, and for you can ask a question to Ms. Darample. I also want to commend Mrs. Spurzavi, the Chief Parliamentary Draft Person within the Office of the Attorney General and within the Ministry, who does not talk much, but is a very, very hardworking individual, a very good technician in what she does. She has worked on multiple pieces of legislation, and I want to commend her for that. She would have been here for us this morning, but she had a mishap this morning. Just like me, those things do happen. And so, again, Ms. Darample, thank you very much for your tremendous work. I want you to say to the public that we have excellent public officers within the government space. I can recall when a certain justice was retiring, and he asked to meet with me before he left. And he cited 5 young attorneys within the Office of the Attorney General and within the Ministry that he said to me, Mr. Minister, try to keep them. One has left, but I'm happy 4 of them are still with us, including Ms. Darample. So we have to continue to work with what we have and to actually encourage our young people and to continue to serve this country. Your government has tried to build a dynamic Dominica, but that's going to require also a sense of order, and appreciation for the rule of law, and protecting each other, and being each other's keeper instead of criticizing each other. We must point fingers in the right direction. And as I'm there, so the floor is now open for questions. But before we open the floor for questions, just permit me, the last time we met here by way of a press conference was a very disturbing and unfortunate situation then, and it still remains with this innocent Kenisha Alexander, who up to now has not been actually found. We have to continue thinking about her and praying for the best. And we within the government and the police will not rest until some element of closure is brought to this matter. As we speak, you have a team of investigators working on this matter, looking at all elements from what I've been advised and what I know of that case. No stone will be left unturned in that regard, and to continue with the search and working on every lead and building on the talent that we have, and of course using whatever additional resources that we need to have. So I want to commend the public for their support so far in that regard. My last comment I want to make before we take questions relative to what was presented here this morning has to do, again, I was informed this morning by the Chief of Police of another shooting resulting in the death of somebody else. I don't have the actual detail as to the name of the individual yet, but that is very disturbing as a country, and that nonsense has to stop. It has to stop, and we will provide the police with every support, and some people in the public are not going to be happy. Some people in the public are not going to be happy. But we cannot allow in a small country for this nonsense to continue. The lieutenants and the generals have to be identified and dealt with. We have to assume, of course, a holistic approach, but fundamentally, we have to get to the root cause of this matter, and those who are responsible must face the full weight of the law. The public will call on you also to assist, but I'm saying some people are not going to be happy. There has to be a central authority to deal with this nonsense when they occur in the country. We have been through this thing before, and we made it as a country. Yes, we can say it's a regional and global phenomenon, but we have to do what we have to do as a small country to confront this matter and to deal with it. There are certain things I cannot disclose as a minister, but of course, this nonsense has to stop in this country. The floor is now open for questions. Thank you very much.
Thank you very much. My first question to the head table is basically the issue of grooming, which the PS just mentioned and the PSU you referenced as well. It just brought to my mind the concept that all of these terms and so on, that there are certain things that happen that people are not probably in a position to word it properly, to understand what it really is about. And so my question, the core of my question on this one is the process of educating or people, public education on not just this aspect of it, but the entire Sexual Offender Act as it has been amended and so on. So any of you who wish to speak to this, could the necessity of the public education. I know this is a perfect opportunity here today, but going forward, what else is there that we can do to keep people aware, cognizant of these aspects? Because the PS is right, this thing will be happening, but people don't quite understand. You hear grooming, some might be hearing it for the first time, some of us understand what this is about, but the wider public needs to understand it is a thing. Let's just say something, people may not be thinking of this. They may think, well, okay, someone is providing certain maybe facilities, it could be cash or whatever it is, doing certain things for certain minors, and it appears like they're being nice, being kind. Parents might think, well, this is wonderful. Somebody is buying my kids the school books or shoes or what have you. And then you don't realize, that parent might not realize that we're talking about grooming in some instances, and it's illegal, but people are not aware. So you might just think, oh, this is just a nice neighbor, but an illegal activity is taking place. So the education of the masses on those things.
Okay, I think the PS and the DPP will answer, but let me just throw myself. You see, what we're trying to do from the ministerial level and from the government level is what every government should do. But within the societal space, you have people with a certain level of competence. When we were actually developing that bill in the draft form, it was initiated to an extent by a number of interest groups. They made written submission. I met with several of them, and they gave several submissions. So they themselves are very much well versed of the elements of that piece of legislation. And instead of crying foul whenever something happens, they also have a responsibility to as reasonable and citizens of reason, to bring it out to the general public by way of edifying them as to, hey, that exists in our bill, and there's a certain responsibility on you as a parent, as a teacher, as a good citizen. You understand what I'm saying? And we have proceeded to revise our laws, and where all the various pieces of legislation that existed before are in one consolidated document to make it easier for you to read and understand. And then you have lawyers within the private space, and you have various people who actually present themselves as concerned citizens. It is an excellent opportunity, therefore, for them, if they're bona fide in their expressions, again, and I guess that they are, that they'll go out there and to educate the public on the various aspects of our piece of legislation so that they can be more informed. So whereas the government has that responsibility, but there's also a collective responsibility within society, beyond the government space, to engage the public on those important matters. So I wanted to also add my voice to that particular part of it because I feel very passionate about this thing. But we know that is why we're doing that. We're leading from the front to bring the information out there and so people can have an understanding. Because a number of people, when they hear this thing, is out of concern and they may not be aware, the ordinary man on the street may not be aware on a certain element of sophistication in actually reading certain sections. So we need somebody who is versed to break it down. And that is why in a while the DPP will break down what is grooming. Somebody, for matter of fact, asked me if somebody is sending messages, text messages to a minor, etc., etc. Of course, that in itself is a no-no, and then she can make reference to that. But that is the intention here this morning, to actually engage, and we're hoping that the media can ask questions that can benefit the members of the public, and to give them a better perspective of our laws, especially as it pertains to what we're addressing here this morning, the Sexual Offences Act. Yeah, so I'm not sure.
Okay. Grooming was put in the law in 2016, so it's one of the amendments, and it's found at section 22A of the Act. And it states as follows: an adult person is guilty of an offense if A, having met or communicated with a minor under 16 years of age on at least two earlier occasions, he or she, 1, intentionally meets the minor, or 2, travels with the intention of meeting the minor in any part of the world, and at the time of the meeting or travel, he or she intends to do anything to or in respect of the child during or after the meeting in any part of the world, which, if the act were in Dominica, would amount to the commission of a sexual offense under this act, and does not reasonably believe that the minor is 16 years of age or over. As I told you, the maximum sentence for this offense is 14 years. Grooming basically is you entice a child and you are communicating two or more times with that child, with that minor, and you arrange to meet the minor, and when you meet the minor, you are there for some indecent. You may not commit the act, but your intention is an indecent act with that minor. This is grooming. Also, we also have procurement. I think we may have procurement, which is at section 18 of the Act. And it reads, a person who procures or induces a minor to have sexual intercourse with any person in Dominica or elsewhere, conspires with any other person to the effect the procurement of a minor as aforesaid, procures another for prostitution, whether or not the person procured is already a prostitute in Dominica or elsewhere, or procures another to become an inmate of a brothel, whether the person procured is already an inmate of a brothel in Dominica or elsewhere, is guilty of an offense and is liable on conviction for 14 years. And where the procurement involves a minor, they're guilty on conviction for 25 years. So we have grooming. Both these offenses involve a certain level of communication with the minor. Grooming involves communication. Procurement involves you communicate with a minor to induce the minor to have sexual intercourse with you. And when a minor is involved, the maximum sentence is 25 years imprisonment. And we must also have regard for Section 31A. I like Section 31A because it gives a mandatory minimum sentence. That is 2/3 of the maximum sentence where you have certain aggravating factors. And this is room for departure from the sentencing guidelines.
I want to address the portion of your question that spoke about the acquisition of the necessary knowledge by persons in the public. I understand why grooming might be a tricky concept because we have a strong nenen and power culture. What I would say though is to monitor the relationships that your children or minors have with adults who are even in your household, but especially not of your household or household adjacent. Another thing I would say to you is the minister pointed to a very important way in which we gain knowledge. This is part of our society already, which is you go to your pastor, you go to your priest, you go to your nurse, you go to your parent, you go to the people, you seek the advice from them. Dominica, of course, is one of the territories where our laws are actually online. And so, through the Dominica portal, dominica.gov.dm, you can monitor it almost daily like you look at DNO. There's always tips and tricks and tidbits and information. There is the government internet website, so there are places that you can seek the information. I noticed that you did mention that in your question, and you focused on that a bit, so I didn't want to leave out that element of it. We don't expect you to be born with certain knowledge, and certain terms have a legal name that you may not be aware of. So my advice would be, of course, to monitor, any external relationships as far as you can that your children might be engaging in. But it is also important to seek the information. We can put the information out there for you, but we cannot make you curious. And so you have to be curious to some extent. You have to seek that information. Where is it? In Dominica, you're fortunate because it is actually online.
In relation to grooming, you mentioned communication. Can you just define that, please? Does it mean face-to-face communication, electronic communication?
Any form of communication.
Smoke signal,
Any
anything.
form of communication.
Smoke signal, anything.
And also, I must say that in Dominica we have an Electronic Evidence Act, which makes provision for the use of electronic evidence. Almost every day I use electronic evidence in court. I have prosecuted sexual matters already, where I have presented in court telephone conversations between the accused and the minor. So communication is any form of communication.
Including WhatsApp.
Including WhatsApp messages. I have presented WhatsApp messages in court already. We have the Electronic Evidence Act, which makes provision for that.
Including letters too.
We're going to do that again, but yes.
And providing the statistics before, you said that for the year that...
You want the mic?
Thank you. So my question is for the DPP and activity BU. In providing the statistics, you said that for the year thus far, one case went through and about 11 of the parents came in and asked that the matters be discontinued. Can you tell us or give us an update in instances such as this? Does the state have the right to continue on with the matter even if the parents ask for the matters to be discontinued? Question number one. I'm not sure if I should ask the rest.
Okay. I will deal with question one and then we move on to two. Okay. It was over the past 2 years, only one individual has come in for an appointment to see me to know the status of their matter. And 11 individuals, that's from February 2020, have come in to ask that matters be discontinued. Now in Dominica, we have a prosecutor's code. And when a discontinuance is being done by the office of a DPP, and it's a constitutional power that I have to weigh the public interest test and the test in respect of the child, the minor, right? Most times we look at the public interest. In times like now, I would be looking a lot at the public interest test. Now the parents are the ones that are responsible for minors. They are the ones who would come in and indicate to me that they're interested in the matter being discontinued. Because I have noted of the increase in that, I do not deal with communication via email or letters. They come into the office and I interview the child and the parent for them to indicate to me what is the reason why they're requesting the discontinuance. Now, the prosecution cannot go nowhere without witnesses in a matter. That's why I'm saying, I said earlier on, that parents have to take on their responsibilities and allow the wheels of justice to turn. Most times it's the parents that come in with the children and say, we're not interested, we have forgiven. I can say that most of the times it's a forgiveness that is being brought to my attention why they don't want the matter to go through. And our children are very educated. I can tell you that the minors that I deal with in court, they give better evidence than adults. They have grown up in a time where they're exposed to the internet, where they follow a lot of things that happen on the internet. Their teachers teach them about sexual offenses. They're educated, they have HFLE in school. They can explain themselves in court. And it's not a matter of they're going to give poor evidence. It's a matter of the parents coming in. The parents are the ones who are responsible for the children and saying that they're not interested in the matters. Sometimes the parents do not bring the children to court. State attorneys in my office have had to go to the homes of parents to find out what is going on with their matter, what is going on, why wasn't the child at court. And we've had days where we spent a whole week preparing a matter for court, and on the day of trial, the parent is saying they're not interested, they don't want their child to go through this. So what we are saying, please allow the wheels of justice to turn. Another thing, parents say, oh, there is a certain level of delay in these matters because of the PIs. But we have decided that we are going to be doing matters through the paper committal route, which involves the minors putting their statements before the court and the accused being committed on these witness statements. And the Sexual Offences Act makes provision for all these things. So we have to consider the parents not wanting the matter to proceed, and whether it's in the interest of justice to proceed, whether we can get a conviction without that child giving evidence, which most times cannot work.
And the parents be charged?
Under the legislation, the parents can be charged for obstruction of the prosecution, which I mentioned earlier.
Okay, thank you very much. My question is now directed to the Minister of National Security. Honorable Blackmore, there have been mounting calls for a sexual offense registry here in Dominica. Recently, an online petition started and received under a number of signatures. People are asking that the names of these individuals who are charged, if they're released to the public, is government taking any consideration to enacting or putting in place the sexual offense registry?
Yes, I have noted that the public domain is asking for the sexual offenders registry. I believe it's something that our ministry can consider at this point because of the prevalence of these offenses. But when we go back to the Sexual Offences Act, though it does not speak to the establishing of a sexual offenders registry, it makes provision at section 38 for the names of the accused to be published where applications are made by the prosecution and also the complainant in the matter. So we may not have it in the term of offenders registry, but there is provision for after conviction for the names of the accused to be published. And almost all the time, you at court very often, you see that the judge gives a sentence where you have the full name of the accused. So it's out there in the public domain who are the accused individuals. Almost every time the judge gives a sentence, the name of the accused is published. For the protection of the child, most times we will not state the child's name, but the names of accused are already being published. And another critical thing I must add too, upon conviction, section 38A, that's an amendment from 2016, there is provision is made for an order, for the court to give an order for a convict to be medically examined. And where it is found that he has a sexually transmitted disease or HIV, that this information can be passed on to the complainant, and the complainant can also seek compensation where the complainant has been infected by that accused. So this is how comprehensive our act is.
Thank you. Just to support what the DPP has said, the police, for matter of fact, has what they call a rogues gallery. And that rogues gallery, of course, contains the name. Okay, let me just start again. My mic was off. Historically, the police has kept what is called a rogues gallery with the pictures, photographs, and the type of offenses various offenders have been convicted for. And certainly, I mean, as we go forward in terms of ensuring that the public knows of someone who is a potential threat, especially as it pertains to minors, something that we have to give consideration to. But also, a balance has to be struck going forward. You may have some people who have served the time and who have been through some element of reform, having served the time and been out in the public domain. And one has to be also taken into consideration that you have people who have been able to go through a certain element of reform after having served the time. So that's a balance has to be struck, therefore, between those two. But when we met during the discussion and the consultation that we had to inform that piece of legislation, that was one of the recommendations made. And of course, that's something the state will consider going forward. Yeah.
And finally, any consideration for the age of consent here in Dominica is presently standing at 16. The organizations are calling for it to be increased. Is government taking any consideration into our age of consent?
To consent?
Age of consent. Age of consent.
In terms of bring it down, bring it up?
Bring it up, I guess. Hi, you need to clarify. You mean the talk we have of increasing it to 18 years. That's what you mean? Okay,
yes,
wonderful.
it's presently at 16. There are talks to increase it to 18. Just some thoughts on that, please.
Well, you have had several recommendations and persons have expressed views insofar as age of consent is concerned. I know I wish to start something I never supported, that there was a school of thought presented by some people that the age of consent should be lowered. And I'm not sure if you heard that. And that is something I think that in this current environment within which we reside, nationally and regionally, as you heard, notwithstanding the fact that you see people have emerged in terms of their understanding, but at the same time, a minor is a minor. And then so we believe 16 years for now should not be lowered to 14 years. So there's a discussion that can be had as to whether it should be increased to 18. Because some of the merits used to actually bring forward or push forward that sentiment is that you have to vote, you have to be 18, was to the effect. And so it's something that we can continue to talk as a country, but fundamentally we have a piece of legislation that is very, very comprehensive in scope. And if all of us do what we're supposed to do, we can provide that level of protection and security for minors and other vulnerable groups. Yeah.
There's I think someone mentioned it, but this is always an interesting conversation when it comes up. The concept, DPP, of people, the possibility that within the confines of the marriage arrangement, that one could be raped. If you could comment on that.
Basically, the law, as it stands right now,
Your mic is on.
as the Honorable Minister stated, which as it stands right now, is that a husband can rape his wife and a wife can rape his husband. This is it put simply, according to the Sexual Offences Act, Chapter 1036.
Yes, I'd welcome comments from anybody else on that here who would like to weigh this topic.
Now, the fact of the matter is, some people look at it from a religious and spiritual standpoint. And as I said before, the Bible sometimes is misunderstood and misconstrued by many. And that is done sometimes out of convenience. I am not a priest. I'm not a lay preacher. My wife is, and my father was. But I do not believe in the notion that a man or a woman, and for matter of fact, anytime a wife were to report her husband for rape, then that marriage is over. There's no marriage. You get my point? Now, that piece of legislation has been put into law. How many wives or husbands have reported? You get my point? But the fact of the matter is, it is actually absolutely outrageous for anybody to think, because you're married to somebody, that you have a right to forcibly rape that person. Let's put it in graphic terms. You go out at blast and spend all your money and gamble all your money, right? You spend 2 weeks not coming at home. You're not providing for your family, providing for your wife. You come home drunk. You may have, as you heard, a sexual transmitted disease, and you want to force your wife to have sex, and she have to say yes because she's your property. Marriage doesn't mean that somebody else is your property. And I think a marriage has to be based on mutual respect. You see? And we have to understand that. And the reason why you find there's a hoopla among a particular segment within society, more so the male segment, is because we men know that the aggrieved party or gender is a woman. Notwithstanding all the gains we have made in society, society still remains a male-ordered society. So I think it's absolutely mind-boggling to me for anybody to think that if you're married to a woman, that when you want to have sex, you must say yes. So your wife has a headache, my friend. My wife has a headache, right? And she gave birth to a child a couple of weeks ago, and you want to force her to have sex, and you say, that's your wife? I mean, I'm outraged by that notion. And I'm saying, and I say it again, I was struck by the number of text messages I got by ministers of churches of religion warning me about that intended measure. So I want the priests and the pastors and them to tell me, when the Bible says, husband love your wife and wife loves her husband, what does that mean? If you love your wife or husband, you can't rape your husband or wife. Do you get my point? And I think if we're talking about the way we treat other people, minors, we as adults must demonstrate that sense of responsibility and respect. That is my personal view on that. I mean, you know what I'm saying? My wife is not inadequate to me. You get my point? I see my wife as an equal party in my relationship. I cannot force my wife to do anything. I can't force my wife to think about anything. And any person who's married to anybody, and every time you say something to the person say yes, honey, you know you're in trouble. You're in plenty of trouble. Because the fact of the matter is, our wife is supposed to have an opinion and a brain of her own. And she ought to be able to tell you at some point you're talking nonsense, or I don't agree with you. You understand? Likewise, the husband. You get my point? So we have to understand those things, you see? And sometimes people walk around quietly and always praying, watch them fellas, you know? Watch them fellas. And they look at folks like me who have a front and think, you know, what you think that? But I have no respect for any man, my friend, that raises his hand on his woman, his wife. Well, it's not a woman, it's not a thing. and your partner. Likewise, I do not see why a woman has to hit her husband. It does not happen, you get my point. So all those things have effects and impact on our children. Because children actually practice what they have seen. Yeah? And we have to understand that. So I'm happy you asked that question. And I know some guy's going to be vexed with me, but I'm cool. Understand? You're married to somebody, the person have said I do, it doesn't mean I do. To be raped, as simple as that. So I support this measure 110%. I can defend it.
Honorable Minister, if I may, I think it's very important to remember that in an ideal world, you might not have any need for legislation like that. Bearing in mind that this has been law in other parts of the world, far before 2016. So we're not, quote-unquote, breaking any ground here, we're just breaking ground in Dominica. I think it is important to remember that the role of certain legislation is to preserve bodily integrity as well as dignity, which are just basic human rights, really. And that I think you should put all legislation like that talks about how you cannot forcibly violate another person's body, space, mind even, into that broader perspective. And perhaps it will make it much easier to rationalize and accept some of these positions, if that helps.
Yes, I know. As we
No, it's not on.
Yeah.
Okay, yes. As we keep discussing this issue of Sexual Offences Act, and so I was thinking a bit about the difficulties that would arise if, we know adults, caretakers, generally we're supposed to be the ones protecting. The problem that comes up is when you have, it could be a school teacher, it could be a pastor, even in a church setting, being the perpetrators. This is where I would think was listening to us this morning, you might be thinking that there are difficulties in these areas where people are intimidated in terms of coming forward. Look, I feel my priest or my pastor knows better, so how do I don't want to report this thing, I want to keep it hush-hush. That presents a serious problem in and of itself. I'm not sure what your thoughts are on that. When the people who are supposed to be protecting are the ones perpetrating or perpetuating.
Madam DPP, I do believe that there was a section that you pointed out that speaks about some of the aggravating factors, and one of them is persons who are in positions of trust.
Breach of trust.
Breach of trust and etc. So I think that, yes, exactly. So the law recognizes that issue, and this is why it is there. As for people finding courage to come forward, we are hoping that by the behaviors and grooming that we can do with police officers and the prosecution and persons who are supposed to support your effort will go a long way in giving you the strength to come forward. But I will let her expound a bit on that section because she did mention it in her presentation.
Adoption of children, bill, take away a child. I don't know.
Well, the legislation, as I indicated earlier, makes provision for individuals who obstruct the prosecution of these matters. And also, there is a very important piece of legislation, which is the Criminal Law and Procedure Act, that speaks to perverting the course of justice. I have dealt with matters already where parents would tell the child, don't report it, and they would go to a teacher. The parents would be somebody who is in charge of the child, and they would go to a teacher, and the teacher would be the one making the report. So we have legislation in place to deal with situations of that nature. That is the Criminal Law and Procedure Act, which speaks to perverting the course of justice. If someone is being threatened from making a report, they can also be charged. So you would have the individual being charged for perverting the course of justice and also for the sexual offense. Both charges are indictable. And the Sexual Offences Act speaks to obstruction of prosecution of the matter. And also, as the PS pointed out, I said earlier on, that the court in sentencing also considers that as an aggravated factor where the minimum mandatory sentence would be considered. This is one of the aggravating factors. If you threaten the individual, if you abuse a position of trust, that the court has to depart from the sentencing guidelines and give you 2/3 of the maximum sentence.
If I may, just to add to what the DVR just said, certainly to work in conjunction with the Sexual Offences Act, we are going to also require other attendant pieces of legislations so that you can build the kind of capacity that you need to build within the system that will provide for the removal of a child from a particular setting once there is suspicion that that child is being abused. And you may have heard that we are going to consider before Cabinet a number of pieces of legislation, family legislation. One we just Cabinet has just cleared a couple of weeks ago has to do with the adoption of children, where you will have a situation whereby a director will be appointed. That's what the law speaks to, the proposed law. And in the event there's any element of suspicion, and that child can be removed. And then there's a process within which, after a period of time, you can go before the court where we have a court order. But that will require, of course, the improvement of a proper foster care, proper support system to ensure that the child's welfare can be maintained and can be preserved. So there are a number, it has to be a holistic approach, so to speak, and to complement what we have already and subsequent pieces of legislation that we've, of course, put in place infrastructure, because we're going to have to require the foster homes, persons, additional staff within the, people who are trained within the welfare department, et cetera, and going forward. Yeah.
Question. How is the DPP's office working towards speeding up the processes? Because sometimes we get an arrest made in January, you return to court in March next year, especially in cases like that, especially at this time, with some high-profile cases being out in the public domain. While you cannot speak about it, but how is the DPP's office moving to speed up the matters? And second, what if the parent wants to discontinue, but the child wants to continue? How much say does the child have in going forward?
Okay. To speed up the matters, we are currently considering paper committals, which makes way for the PI, the preliminary inquiry, to be cut down significantly. I had experience in paper committals sometime in 2015 where an accused was convicted within 6 months of being arrested. That was the first paper committal matter that I worked on at the time. And it shows that matters can go through, sexual matters can go through the system quickly if we use that route. The legislation is there. It's Chapter 1203, the Preliminary Inquiries Amendment Act, where it makes way for the presentation of witness statements to the court, and then the accused is committed to the High Court. I'm also in consultation with the Permanent Secretary for us to consider a paper committal unit because of the number of matters that are now before the court, to speed them up, the sexual matters. And we understand that in sexual matters, time is of the essence, because when the children are of a certain age, they have exams, they have school to attend to. That is what they're supposed to be doing. School, to attend to church, sports. We do not want to be taking up all their childhood time in court. So we are looking to speed up the matters through a paper committal unit at the Office of the Director of Public Prosecutions. And also, Mr. Titu, the other question was that, what if the child wants to continue the matter? That's the perfect situation for me. Most times when I question the children, they agree with what mommy and daddy says. But if the child wants to continue the matter, I would have to get the counselor involved and the welfare department involved so that they can appoint somebody to be the guardian of that child, and then we take the matter on with that child. So to add, the welfare department also plays a critical role and provides support in the fight against sexual offenses. Because it's this department, we look towards them to get guardians for and foster care for children. Also, they assist in presenting what is called social inquiry reports before the court. Almost every day they present these reports before the court, which gives the court for sentencing a feel of what that child has gone through, what are the effects on the child, and how can the child be rehabilitated in respect of dealing with that incident. And also they look at deterrence and the offender. These are the considerations that are given to the offender, the deterrence, the prevalence of the offense in society. So we have the reports that look both at the offender and the victim in the matter.
Okay. So on this, I'm not sure, Madam Deputy, if you want to just maybe share some further light on the whole issue of paper committal. Sometimes, of course, most times it's going to require, for it to be effective, the consent of the accused for his defense team, his lawyer. So I'm not sure.
It does not. What it requires is that the accused has to be represented.
Right.
So it's basically something that is in the purview of the prosecution. What we do is that we put the court on notice. After reviewing the file, we put the court on notice that we are going to do this matter by the route of paper committal. It does not give an accused much leg room to oppose it. If he's not represented, we would contact legal aid to provide representation so we can speed up the matter. So all we need is that the accused has to be represented first to do the matter through the paper committal route.
Madam DPP, in this case, is the welfare division, is the child taken from the home and the welfare division takes care of the child? What if the child undergoes some sort of pressure or abuse at home from parents? Why do you choose to continue the case? Because again, you have to protect the child.
The answer to this question lies in the Sexual Offences Act, because we have the obstruction of prosecution. That is something that the Welfare Department would bring to the attention of the police, and the police would prefer the necessary charges under the Act. And usually the Welfare Department, what they do, they have counseling sessions with the children. They also have case managers where they're doing checks on the development of that child in school and what is going on, and they bring back these reports to the police.
This might be my final. This might be my final. Sorry, this might be my final question, I'm not sure. The issue of adequate vetting of prospective guardians through the child welfare system. My concern is that there may be, I do not have any evidence to give to present here now, but there may be instances where children who are adopted are not having too much of a good time by whoever it was who adopted them. So I'm just throwing this out as what is the vetting like? Can someone just go in and say, look, I'd like to to adopt a child? Because I've seen instances where people have told me in conversations, yeah, I'm going to adopt it. But I'm like, hold on a second, but I mean, who am I to judge? But my concern is the welfare of the children, and who exactly is it who is getting to take these children home, and the welfare of these children, and whether or not there's some sort of follow-up to check on these kids and see if they are doing well and they're being well taken care of.
Well, I know that the Welfare Division has protocols when it is an adoption or guardianship or going through their department. Outside, if it's an issue that is outside of the department, they would not have much control over what happens, because remember, we live in a society where sometimes an auntie or nene can say, you know, this child, let me just take care of this child. This would not go through the Welfare Division. But I know that they have their protocols that they follow. An interview is done for one, and they do follow-up checks on the children who are with guardians through their department or foster care.
There is an adoption act that gives that outlines the eligibility to be able to adopt a child legally. But as the DPP is indicating, adoption in Dominica and in the Caribbean can look like many, many things. So just because you hear a person saying they're adopting a child doesn't mean that they actually went through the process, and the welfare would not be able to capture all of these. But you do realize that some of what you're asking about is a little more fitted for the welfare division. So I hope at some point we get a chance to bring them into a discussion with ourselves to address some of these issues. But if you're asking, is there a criteria for adoption? Yes, there is. There is a criteria for adoption. It is in the law. I know for a fact we do background checks. If you're adopting a child, they do a background check. And that even, if you're even overseas adopting a child, that is one of the requirements by the court, that you have to have a division of some sort, speak to your fitness and whether or not you should have a minor or whatever child in your care. I know that to some extent they're very careful with that from my knowledge. I mean, my knowledge is a bit old now, but I am talking about my days when I was at legal age, where we did a lot of adoptions. So there is a process, there is a procedure. It is very meticulous. There might be other challenges, but it is a very meticulous process. It's off, oh, sorry.
There was a case involving a what was then a high-profile person, a sexual matter, which was put up for judicial review. I do not know if the DPP would have any update on that. And just not to prolong the discussion, but what is the difference between adoption and foster care?
Foster care is temporary, adoption is permanent.
I will let the DPP address this part.
In respect of the judicial review matter, I think you may be referring of, the matter is still before the court, it's in the High Court. Now, what happens with judicial review? When an accused asks for judicial review, most times the criminal matter is stayed, meaning it's stopped for a time. We don't do any prosecution of the matter until the judicial review is heard in the High Court. And the Office of the Director of Public Prosecutions does not defend that judicial review matter. It will be defended by the office of, the chambers of the Attorney General. So what happens, as long as an accused has gotten leave for judicial review, the criminal matter is stayed, meaning the office of the DPP cannot do any work on that matter in the court. The court stays it until the outcome of the judicial review matter.
You asked about the difference between adoption and foster care. Shona, I hope I'm correct on this. I would imagine that adoption has a measure of permanence, whereas you actually legally become the parent of that child. Foster care might be a more temporary situation where she may, let me use one of the examples that she alluded to. She indicated, for example, that if a child wants to continue, they can be put into guardianship or foster care until the matter is concluded. So foster care, to my mind, can have a level of impermanence. It can be temporary, can be for a situation to facilitate something, to immediately rescue the child. It can be a halfway situation where we rescue the child temporarily until we find more permanent residence. So that to me is foster care, and it can of course encompass all of the variations. But adoption is a more permanent process where you become the legal guardian of the child and you become the parent. And that is actually reflected in the records of the child, where the child's birth certificate is replaced with an adoption certificate, which now means you as the parent. So to my mind, that is some of the differences. You have a question?
Hi, good day. Because there is DBS Radio. I just have one question. In regards to persons who are being prosecuted as sexual offenders and that be reinserted back into the public, what stipulations are in place for where the chosen workplace may be? So let's say someone was being accused of a sexual offense. How do we put in measures in place to prevent them from being involved around something with children or persons that they have been prosecuted against from being in that type of area again?
Okay. For one, when you are convicted of a sexual offense, you would have what is called a conviction card. And I know employers would ask for you to get a police record. So at the Criminal Investigations Department, where the records are kept, your conviction card would show that you've been convicted for a sexual offense, and this would be, when you come for your police record, this would be reflected on your police record, and this is enough notice, I would say, for any employer. Let's say this person is looking to get employment at a school. This was, to me, this is sufficient notice for any employer to say, listen, you're not suited for that setting. You're not suited for that form of employment. At the DPP's office too, we've had people who have gone up for, decided to go up for village council, and police officers have come requesting information as to what happened with matters that they had before the court. One of them was a sexual matter. So we know that due diligence is being performed by certain employers in respect of knowing what are the records of the people that they employ. And the records are kept at the Criminal Investigations Department and also at the police stations in whatever village that the individual is from.
Are there any more questions? Before I hand back over to the minister, I really want to thank the press for their engagement and participation. Thank the Honourable Minister, the DPP. I think this was a very stimulating discussion, and I look forward to the feedback that we will get. Honourable Minister.
Thank you very much, PS. Thank you, Madam DPP, and thank you, members of the press, for a very interactive engagement and interaction. As I said before, we intend to continue that endeavor, one of engagement and edifying the public on various aspects of our laws, where we shall be looking in due time at two of the legislations that have caused some debates in the public domain. One, of course, we have heard a lot about the mental issues relating to mentally ill people. And of course, that act places a collective responsibility on family members to work with the health professional and the police officers to ensure that people who suffer from mental illness can be given the best possible care. And the relevant chapter is chapter 4062 of the laws of Dominica. And I think that is one aspect of our pieces of legislation that we may want to look at going forward, and also the Firearms Act. So thank you very much, and I hope that you are leaving there today much more edified on the Sexual Offences Act. And just to reference to what Mr. Darrell just asked from GIS relative to foster care as opposed to adoption, I think the PS is right. Both such cases, you'll have legal responsibility over that child. In terms of foster care, you may have a facility where that facility has legal responsibility over the child. In terms of adoption, you may have parents, adopted parents, having legal responsibility over the child. So one might be a society, one might be a facility, one might be something else, but so far as adoption is concerned, it speaks to parents, adopted parents. And just to add some to what the PS have said. So thank you very much to everyone, and have a nice day.
There are refreshments, so you can please join us. Thank you.
Thank you very much.